Okay, good morning, good afternoon, good evening, wherever you are watching us from. It's a pleasure again to have you here. You are watching Spoon TV live. It's coming to you from Temple of Justice here in Monrovia. So we've been updating you, our audience, about the ongoing trial of former Speaker J. Funati Kofa and several other lawmakers allegedly involved in the Capitol building arson, and also other co-defendants in this trial, some of whom are at the Monrovia Central Prison and the Kakata Central Prison. So our reporter Melvin Jackson will be giving you update of about the hearing in the court and what the defense and the prosecution have been arguing on this particular matter. So Melvin Jackson will join me in a jiffy. But my name is Haji Masalit. We are here at the Temple of Justice here in Monrovia. So the case was just adjourned at the Criminal Court A, and the witnesses will be retiring from the court. I understand they are still placed on bond, but those all co-defendants are still languishing at the um, Monrovia Central Prison and the Kakata Central Prison. So, former Speaker Funati Kofa, Dixon Walawi Sibo, Abu Banan Kamara, Jacob Debbie, and others um, are involved in this particular trial here today. Um, our reporter Melvin will tell us as to whether all the names just mentioned were present in court and what was their appeal or what have been arguing on for today. What they have been arguing on for today, because court process is not any hurry thing. Every appearance, prosecution or defendants or defense will argue on some issue to ensure that their clients are free from those. But here is our former Speaker J. Funati Kofa smiling, and he's with all of family members. Honorable Kofa, you are here today again. Can you tell us exactly what did your defense team have been arguing to ensure that you are free from this?
Okay, so I think last December we all treated to the term ultra virus. The term you gotta take today is called fruit of the poisonous tree. It means that when you gather evidence illegally, you can never use that evidence in a trial. And what we saw today was phones were broken into by the police on December 19th, sent to NSA, and then the warrant was gotten on January 9, 2025. It means that's the fruit of the poisonous tree. It means all that evidence. The fruit of the poisonous tree comes from the Garden of Eden, right? God said you can eat everything here except for this fruit. That fruit that was eaten by the police cannot be used. That snake baby, it must be tried.
The other term is invasion of privacy. So exactly, he talked about eating of the fruit in the Garden of Eden, which some of the fruits are prohibited, or while another fruit was eaten, which is prohibited. So this argument is still pushing is that the okay. So Arthur Johnson is a very good. Let's talk about Arthur Johnson.
The law in our jurisdiction is clear. The criminal procedure law. You are not forced to file the magisterial court. You can also file a motion to suppress the evidence in the court that has trial jurisdiction. And so the court that has the trial jurisdiction is Criminal Code A. And the key questions that we raise regarding the case is that
The issue is that
you asked me, you're not waiting for me to submit.
your defense team filed similar motions before the magistrate.
That's why I'm trying to give you the information. This code is a proper code because it's the code that has trial authority. And you always find out when there is an indictment that is being served on the parties. So after the indictment, there is something we call discovery. The discovery is where you ask the court to compare the prosecution under the doctrine of notice to turn over all the evidence that the government has against the client. So when they do that, they turn the evidence over to you. You look at the evidence, analyze the evidence, and if you have any reason to question the evidence, that is the stage. So that is the trial procedure. Now, so you will ask, what did we say and what do we really ask for today before the court? The evidence that the prosecution turned over to us speak that the extraction of the evidence from the defendants, meaning the cell phones information that they took from the defendant, that they said they used to have evidence against the defendant, they extracted those evidence without a search warrant. They did that on December 20, when they turned over the case to the National Security Agency, the NSA. NSA was the one that conducted the forensic analysis of the evidence on December 20, 2024. And then, looking at these defects, they knew that these were procedural defects that would be questioned at the level of the trial. So on January 9, 2025, after 1 month, then they asked for a search and seizure to what? To say that the evidence were collected on January 9, when in fact they have already collected the evidence and seized the evidence on December 20th. So when you do that illegally, because without a search warrant, without an application to the court requesting for the search warrant, then the evidence is faulty. So when you hear we were saying that the evidence is faulty, and that all of the other evidence that came as a result of that illegal conduct carried out by the NSA and the police must be suppressed, meaning it can be used against them. That is our law. The next argument we raise is that it is law. Supreme Court has said that in the case CC Nete Blankwe versus the Republic of Liberia, that case was decided in 2009 by the Supreme Court. Delivering the opinion on behalf of the court was former Justice Janet, Kabina Mohammed Janet. The Supreme Court said, NSA is not a criminal investigation agency. NSA cannot investigate arson. The report that was sent, you will see there, NSA, arson investigation. Extraction of evidence by NSA, the cyber security unit, is December 20, 2024. When the search warrant talks about January 5, 2025. So you did what you did already illegally, and then you went for search and seizure way January. So it is illegal. It can't stand. It is not anything like sentiments or anything like whims and caprices employed. It is nothing like dilatory procedural tactic employed. It is an issue of law. And the evidence on their face show that yes, that is what happened. So NSA has no authority to investigate. NSA is only responsible for clandestine operations, national security intelligence, and functions that they can carry out are only defined in their act creating them. Even the Minister of Justice or the President of Liberia cannot delegate to the NSA an authority that the NSA does not have statutorily to perform. No. In that opinion by the Supreme Court said NSA shall not engage in investigations that should be conducted by the Liberian National Police and at that time the National Bureau of Investigation. Now it is dissolved, it is the Major Crime Unit. So that is the issue before the court. It is an issue of law.
But the state prosecutor, Councillor Rachel Scott, was saying something on the contrary, that they they do a communication to the NSA to come to assist them.
Authority, Toby, you've been around here for long, more than any other journalist. Authority is not conferred by consent. Authority is conferred by law. Supreme Court said the act that created you is the one that gives you the authority to perform a function. If that act did not expressly state that you can do this and you do anything outside of the express authority of the act, your actions are uttered virus.
So what case the state, what case the court deny the application? What would be your next?
Of course, you know what we'll do again. We'll go to Supreme Court. And that's an issue of law. The law has remedy. But I don't want to preempt the judge. As an experienced judge, we leave him with what we say. I am just telling you what we said today before the court. And we leave it on his lap to use the law, because he's the law judge, to use the law and apply the law to the applications that we need.
Finally, counsel, if you have a strong defense, why don't you go through the case and then flush the state during the full trial?
This is what the law says. Toby, I will not be angry to answer you. I will be happy to answer you. The law says when the person is accused of a crime and that person is taken to court, if the lawyer finds out that the procedural dynamics employed in the collection of the evidence are illegal, the lawyer has the right to suppress those evidence. You can't wait for trial. That's the law.
So you want to suppress it?
Yeah, we're suppressing the evidence. That's the law. You're welcome.
So Arthur Johnson, they're indicating that they are doing everything to suppress the evidence. The NSA cannot investigate criminal matter, and all of the pieces of evidence submitted to the court by the prosecution are all NSA related investigative report, which cannot be presented to the court for prosecution. So it's left with the judge to accept or deny that, and according to him, if that happens, they will proceed to the highest court in the land. That's the Supreme Court. And whether the Supreme Court will uphold the judge's opinion or whatever, then they will come back to the lower court, that's the criminal court A, to go into the trial. But our reporter Melvin Jackson has been following these developments in court. He's now here with me. Melvin, you will take the microphone. You will just give a summary of what happened in court and why are we here.
Thank you, Haji. You know, we just from court. So this morning when the case started, the defense lawyer filed two motions. One is intended, to suppress evidence, against the defendants.
Yeah.
While the other one is intended to ensure that the state bring those defendants who they incarcerated at the Kakata Central Prison.
Yeah.
So that motion was first argued, and they could understand that it was not necessary to take the co-defendants to Kakata Prison, knowing fully where the court that has jurisdiction over the prosecutions is in most other counties. So why carry this matter to or carry the defendants to Kakata Prison? So the prosecution to continued and said there is the state right, and the state has the sole authority to take the defendants wherever they want. So on that basis, the state was in no violations of carrying the defendants to Kakata Prison for incarcerations. And as matter is concerned, the defense has not been stopped before from seeing their clients. So there is nothing wrong with it. But then there were some claims, the kind of claims raised before the court, and the judge ruled, creating a motion filed by the defense team, ordering that the prosecution should return the defendant back to the Morvan Central Prison, so that they can have that direct interactions with their lawyers. So that was just part one of it. And then part two is the suppression of evidence. So the defense team lead as the other trustee, as he listened to him, they filed a motion to have the court suppress into the evidence on grounds that the evidence with the involvement of the NSA was illegal. It meets the bounds of criminal investigations and evidence.
Yeah.
So for that reason, the court should suppress the evidence in the case.
Okay.
So the prosecution took contained and said that they.
Yeah, Melvin, you can continue. Maybe we want to talk to one of the.
Yeah, we will talk to the Solicitor General, Councillor Equasin T. Fire, but he said no comment.
Yeah.
So like I was saying, so they said they should suppress evidence because the involvement of the NSA into the entire process was illegal. As the scope of operation of NSA, it has nothing to do with criminal matter investigations. And then they also continued that the defendants, the search and seizure warrant that were issued or pray for from January, that's about January 9, and after the incident occurred, it was illegal because it had no affidavit and attached to it. So on these different crimes, it make the evidence adduced against these defendants as illegal and inappropriate. And such, it do not follow the chain of custody, so it should be struck, or you say it should be suppressed. But then the prosecution continued and said that there were several search and seizure warrant prayed for before the court, and then for the NSA involvement, since they as prosecution never had the sophistications to carry on the search on these different cell phones or whatever gadgets, they needed the institution that has the sophistications. And because a sister institution, which is the NSA, to come and do this job because they do not have that sophistication.
Have we ever had a precedent on such matter where the NSA clear SOP is full of investigating criminal matter that have potential of going to court and so forth? Have we have any?
So during the trial, the prosecution's lead lawyer, Councillor Richard Scott, informed court that during the cyber money case that involved formers in the financial and others,
in which Councillor
Kofa was the prosecuting lawyer. Justice Wright, other justice was also on that case. They then requested that the NSA do some investigations before, because if the cases of criminal natures, the right of privacy is moot. So for that reason, NSA in that cyber case move in and did our investigations. So they were questioning now why is it that it was cool back then? Because at the lower court back then in the criminal code A, the judge or ruling that favor defendant Kofa other justice. Now that the other party went before the Supreme Court, and the Supreme Court also withheld the lower court decision and say it is correct. Now, why is it wrong in this matter that the NSC was being called upon to come and help with these investigations of searching the catches of these defendants? Why is it now illegal, inappropriate, or out of the midst of bound of
but Melvin, why is it that NSA clear SOP is being bypassed and they are going into investigating criminal matters, and the court is upholding to those tenets that are presented by prosecution that NSA can assist the set up institutions of government?
So the prosecution made it clear that there is something that the NSA did not just jump out to say we are investigating, but rather they were called upon. So it's not that they are bypassing our scope of operations to get criminal investigations, but rather they were called upon as a sister institution to the Ministry of Justice to say come and assist in this process because you have all these investigations to help in the process. So that was the issue. But whether or not they could, we are just looking to see what they could, because this thing suppression of evidence started from the lower court during the preliminary hearing at the magistrate court, and that was being ruled, in favor of the prosecutions, where in the defense took an appeal to the circuit court. They see criminal court A that they are before now, and then the criminal court A withheld the magistrate court decisions. Now, the interesting part is the defense team remanded the judge at the circuit court that we came there before, and you said the father was premature, and that we should go the other way. That when we come before you, we will have the review, or we'll have it be filed properly. We are here now, we are filing, and they are, objecting to it. So that was the direct quotations, they held. So the judge then reserved ruling for Thursday.
Okay.
So the two motions, one was granted to have the guys taken for Kakata prison to.
Okay. So who are those at the Kakata Central Prison?
The guy Thomas Eche and the others.
Okay.
Yeah, I will not give you the full name for one of them, but the guy Thomas Eche and the others in Kakata prison, because they allege that they were being tortured, they were being sodomized, to accuse evidence against themselves. So for that reason,
so the prosecution gave any reason why these people were transferred to Kakata Central Prison?
The Mobile Central Prison here was built for 300 plus MOB. Now it is occupying 1,000 plus inmates. So for that reason, they cannot keep this guy there because there is no capacity to hold them. But now the judge in his ruling said, if the state knows that there is capacity issue at the Central Prison, there are people who are on pre-trial detentions, who cases are yet to be heard, not indicted. They should move the court to have many guys released, and also that they can use space to have these guys who are the part of the high profile case, be at the Central Prison instead of carrying them to another jurisdictions, that will create some or communications or spark. Now the defense is saying this is a harder political case, and that the guys have been tortured to adduce evidence against themselves. The guys have been sodomized, and that's a whole different allegations. Which the court in her own judgment will tell us whether or not that is applicable to to the law. So that is it, Hachi. We wait Thursday for the ruling in this suppression of evidence by Judge Receiver Willie. They will better inform our audience the next outcome.
Okay, so Melvin, is like we will take it from there and call it a day, but you just want to recap as to how we get here, which case is this, and you've been updating, been doing exceedingly well, updating the Liberian people on Spoon Page as to the Arson case involving former Speaker Funati Kofa.
Yeah, so thank you. So the lawmakers in the case, after the preliminary hearing, the matter was forwarded to add the circuit court, criminal court A, which of Receiver Woody. Now a motion was filed. This not motion, but the bone was filed in their favor, which is the Kofa and others, and that bone was granted. Having the Kofa and others outside, because number one key issue was they are not at the fly rates. These are public officials who, even if they leave the country, one way or another, the government can request the extraditions back to the country.
To get them back is easier than those other people.
So now with the others, the bond that was filed, the prosecutor accepted to the bond, and they went through the hearing. It was discovered that the bond is fake.
Okay, invalid.
The validity of the bond is questionable. So for that reason, the court says they cannot be released, with the exception of three other who the president did not name as fly rates. So these who the president did not name as fly rates, the court said they should have filed and there's a bond for them, they will have them released. But for the others who are fly rates, they also have to have filed and there's a bond for them. So that's the only way they will get released. So for that reason,
so as of yet, only the lawmakers are outside,
yes,
and those others
they are still in prison.
Okay.
So on that note, the defense team went to the Supreme Court on two separate writs. One, they went for a writ of Sindiwari and they went for a writ of mandamus.
Yeah.
So in that writ of mandamus and Sindiwari, they informed the court that the High Court that the judge ruled if something that was illegal, and the judge refused to accept that bond in favor of that claims. But then the High Court Justice in Chimo or Honor Chiefs, how would they declined to issue that writ in favor of the defense team. Send it back a minute that the lower court should resume jurisdictions and proceed in keeping with law. So this is why we are here this morning. And this morning we came, the defense team filed two separate motion again for war suppressions and the release of the guy from this Cardan prison to the Messenger prison.
And one was immediately honored.
One was honored
releasing
the guy from Cardan prison to the Messenger prison. So they have been ordered to bring them back, to the Messenger prison, while the other ruling is reserved for Thursday, as we await that.
So whatever way it goes, can we call this a win for the prosecution or for the defense? If the defense motion is granted,
the one I was granted, we call it a win because you requested that my people are now safe to where they are. I need them to this point. And I was granted. The court in your wisdom said, yeah, it is true. Bring the ball here because this is where they've been tried. Most of is where they are on the trial, and this is the mean of that it should be.
So that is a win for the defense.
The defense. So for this one, we are waiting Thursday. Then we will have our audience updated as to the outcome of the ruling from the court.
So will it be 1-1 or 2-0?
Which I cannot confirm that before it be pre-judicials.
Okay, Melvin, we'll say thank you. You've been covering this high-profile Arson case from Capitol Building, now at the Criminal Code A here at the Temple of Justice. My name is Haji Masale. We want to talk to some of the prosecution, the prosecuting lawyers or the defense counsel, but journalist Peter Tobe is giving his view on this matter. We will join him.
To have them in court while both the defense and the prosecution team are arguing some of the issues that have to do with the merit of the case, and the same people will be selected between me and you, Aaron, when the court is about to commence the trial. All that juror that you see that they will reject all of them. They will reject all of them as we speak.
Based on ground that they were
in court, the guy had the guy prior knowledge of the case. Even during the juror selection, some of the questions that the lawyer asks, some of the juror there, you hear about the case before. So and mind you now, what you are doing here, this interview is going on the social media. People going to look at it, people going to spot some of them. Oh, the person was equal. Then as long as you can't be begin to lie, say, oh, I know what the case is, then they will begin to show that as an evidence. They will say, yeah, you are in court. You are one of the prospective juror. And you listen to what the people say in court, the lawyers them. You listen to the argument. You see, even Massacre, you listen to General Massacre, one of the lawyers. The container that had because people have been tortured. Rather when the defendant kills them, if the defendant are taking all a share.
Yes,
I mean, we also mark. But one of that, but one of these marks were verified by medical report, and this is what the prosecution was saying. So you can't have them in court. You can't have them in court to listen to the argument. So what expect the juror management to do? Immediately, the defense team raised the notice to the court that we have a submission to make. Whether we should let the defendant, should let all the prospective jurors to leave the court and come back the following day. Because the anticipation everybody had today is that they were going to be a ring in court today. The defendant was going to plead to the criminal indictment, whether guilty or not guilty. Or to have them in court, I can see how the question the state, even the state or the defense team rejecting most of the defendants.
So, Mr. Tobe, with that now, who's to be blamed with the juror being present in court?
Well, in a case, one of the parties should have given notice. For the defense team, because the state is the one that want this matter to be prosecuted. They pray for the assignment. So to tell you that how the cause they are ready. And as I said, Aaron, the issue about prosecution is not all about conviction, even acquittal. You know, I got the word from former Solicitor General, Councillor Betty Lamy Blamo. She always said, and I quote, the issue of prosecution is not to get conviction. Acquittal said acquittal self is justice. Because you went to court to know whether I do anything or I do anything. The court say you do it. So you work now as a free man. Because you were accused by the state. You understand me? So you were accused by the state. So to have the people in court, they were doing court. One of the lawyers, especially the prosecution, because they're the ones that are opting for their case. Because they believe that they have a case. They should have raised the issue with the judge. Say, Your Honor, we noticed that the people filed a submission to the court, and these are the prospective jurors. I don't really think they need to be in court to listen to the argument. Because now the jurors are listening to the argument and they're going to now to start conversing with each other.
Yes.
Oh my man, they think what they say. But they're not loyal.
So meaning it will be a premeditated.
Yeah, they already had insight. And as I said, how they call it, Aaron, when the people come into court, I mean, when the juror, I mean, how they call it, when the state or the defense team, because both of them can cross the juror, the prospective jurors.
Yes.
And when they cross it, and these are all educated people. And when they cross it, then they will ask them, have you ever heard, I mean, do you know Fanatic Kofa? Have you ever heard about the case before? And somebody will, as long as you admit to that, it's a ground to have you as a part of the panel. And you need about 15%. You need about 15% to sit on the case. 3 there will be an alternative jurors, and we get 2 will be going in the room. The reason why you have the 3 there, they there as alternative in our convention standby.
So for now, we cannot tell that this case will be either a bench trial or a jury trial.
For this kind of a case, it can never be a bench trial easily. It will always be a jury trial because. So
you assume.
Remember now, the defense team filed a motion before the court asking the judge to recuse himself because they believe that he has been biased in some other way, especially the issue of releasing the defense. So you think they will go and want a bench trial? How they call it? You think they want a bench trial with Judge Wilson Regular? I doubt it.
Thank you so much.
Except you want to prove me wrong. Yeah, I doubt it. So definitely they will not go for bench trial, but they'll go for it because the issue of a jury trial, you have a chance. As many people will say, if you have 4 persons, 4 out of the 12 say the person not guilty, that hang ready. And you know what I mean? If the state get a team for 9 or 10, the majority. So definitely, I want to believe. I'm strongly believe that with the conviction that this will be a bench trial. I mean, this will be a jury trial. Everything possible, but it will not be a judge with it, except maybe they sign a case how they got it with different judge. Because they who the prosecuting say we trust him, man. They went upstairs. The court said no. The court declined. The Supreme Court declined. And you think they will come to have the man to serve as the juror and the judge, almost the referee and the player? I doubt it. Except maybe they've been proven right. It will be the first time. I mean, in the history, especially when you accuse the man, you say the man can steal. And they don't can't carry them at 10 million to the bank.
Okay, his name is Peter Tobe, Truth FM judicial correspondent here at the Temple of Justice. He's been around the court for so many years, so with that thought to get his insight on this ongoing Arson trial here at the Temple of Justice. So my name is Haji Masale. I'd love to say thanks so much for watching Spoon TV. It's been a pleasure. Thursday, we will be here when the ruling from the judge will be released on whether the motion as filed by the defense team of former Speaker Fanatic Kofa will be made. So again, this is Haji Masale. Many thanks to Melvin Jackson, our judicial reporter here at the grounds of the Temple of Justice. I'm closing, so I want to say thanks so much for watching. It's been a pleasure.